Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right, then, and
Here's a minor. You learned that it was done after different paperwork. As far as the no contact, what the agreement is now, does this case, I guess, continue for the last sentence for CPS record purposes for us to go to them and find out what happened at the CPS hearing. So to make it easy, we are agreeing with the defense that she can't have contact with the children, but there just be monthly field visits for the entire 2 years of the Virginia cases.
did y'all ask probation if they want to do monthly field visits?
I did, and
Parties announced.
Jason Garrett for the state, Your Honor.
and Bernard for the state as well.
We need Scott for the defense.
All right. So off the record for a moment. So they don't have the W to signify waiver numbers anymore?
The clerk informed me at the last setting we did this, but they don't do that.
Okay.
Unfortunately.
All right. Just so I can know where we are. All right. We're back on the record. And cause number ending in 16, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these? I'm sorry, state.
Yes, Your Honor.
Just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, sir. I think
All right,
Gave
King
it
Clerk,
to
so I don't have a
clerk.
copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Let's
copy.
see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 16 with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 62B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 16, you are charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. PR counsel, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 62B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Aguirre, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution.
At the center of this intense and emotionally charged moment, the atmosphere shifts as the defendant steps forward and enters a no-contest plea to both serious charges, instantly raising the stakes. Instead of moving quickly toward a final decision, the judge deliberately slows everything down, creating a powerful sense of suspense that keeps everyone on edge. This pause clearly signals that there's more beneath the surface that needs to be carefully examined before any outcome is decided. The focus then shifts sharply toward the child's safety and well-being, making it clear that this situation goes far beyond legal arguments. It's about real-life consequences and a vulnerable life at risk. As the proceedings unfold, the delay only adds more tension, leaving critical questions unanswered and everyone waiting for what comes next. The involvement of authorities to provide deeper insight adds another layer of seriousness, suggesting that the final outcome will depend heavily on facts that have yet to be revealed. Every passing moment feels significant, as if everything is building toward a life-changing decision. The uncertainty, the pressure, and the emotional weight of the situation all come together, making it clear that the final judgment won't be rushed. Instead, it will be based on a complete understanding of the case, where the truth, accountability, and the child's future all stand at the center of what happens next.
Parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguirre, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right, then, and
There's a minor arm that was done, I guess, after hearing the paperwork. As far as the no contact, where the agreement is now, because this was, I guess, continued from the last setting for CPS record purposes for us to do other than and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury cases. So
how did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they agreed.
All right. So they're asking then for no harmful or injurious contact with Layla Aguirre. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry,
No contest.
state any evidence.
In both cases, Your Honor, state not proven that in cases of one, both have things.
No objection.
And each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow.
For the other one, for some of this one, we got reset for a week, someone.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney.
Okay, that one's
Tomorrow.
Tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But I guess it wasn't possible when we reset it.
Okay.
But if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in so the court can see what's going on.
I think the state can
Have
make
the
it proper that they completed everything.
Here's the thing, in some situations, I don't like proffers because people need to be on the record for what they have done.
Oh,
So,
see if we can get the CPS.
all right, and they can appear by Zoom.
okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing.
Okay.
And sentencing will happen on that day. All right?
All right.
Once
Thank
you
you.
sign the reset form, you're excused.
Thank you.
You're welcome.
As the moment reaches its end, the tension doesn't settle, it deepens, leaving a strong sense of anticipation hanging in the air. There's no clear resolution yet, only a pause that feels heavy with meaning, as if everything is building towards something much bigger. The uncertainty becomes the most powerful element, drawing attention to what's still unknown and what's about to unfold. It's a silence that speaks volumes, reminding everyone that the most important decision is still ahead. What makes this ending even more impactful is the focus on what truly matters, the safety and future of the child, which now stands at the heart of everything. The situation no longer feels like just another case, it carries emotional weight and real-life consequences that go far beyond the moment. The defendant is left facing an uncertain path, knowing that whatever comes next could shape their future in a serious way. As the scene fades out, the sense of suspense continues to grow rather than fade away. Viewers are left thinking about what the final outcome will be, knowing it won't be a simple or easy decision. Every detail, every delay, and every choice has led to this point, where the next step could change everything. It's a powerful ending that doesn't give answers, but instead leaves a lasting impression, making it clear that the story is far from over and the final decision will carry weight that cannot be undone.